Hey, good morning, everybody. Welcome to Law and Legitimacy. If you woke up this morning and you thought you sensed the smell of something like gunfire in the air, or maybe you heard the sounds of bonds breaking, or maybe the earth was rattling, or maybe as you lingered over your morning oatmeal, Cheerios, bagel, or whatever it is you start the day with, you thought, something doesn't feel right in this country. Maybe we really could have a civil war. Well, you are probably reacting to the news of the Colorado Supreme Court's decision saying that the Secretary of State would be wrong to include Donald Trump on the Republican primary ballots in the 2024 elections. The Colorado Supreme Court ruled last night or yesterday, late in the day, in the case of Anderson v. Griswold. And, Mike's put this name up there for a reason. It's not a case involving Donald Trump. The mainstream media won't put Trump's name in the caption, won't inform people of the name of the case. It's almost as though people are afraid you'll actually go out and read it, but do go out and read it. It's a 4-3 decision by the 7-member court. Four justices concluding that Trump should not be on the primary ballot. Three justices concluding that he should. The majority opinion is about 115 pages long, and we intend to discuss it here today. And we intend to discuss its meaning both as a matter of law, but also as a political object. And we want to ponder what it could mean for the health of the republic. The issue, obviously, well, maybe not obviously, depending on whether you've been paying attention. The issue is whether, under Section 3 of the 14th Amendment, Trump is qualified for office. Not every person in the United States can run for president. You have to be at least the age of 35. You have to be what's called a natural born citizen, and plenty of people want to argue about what that means. You also have to have resided in the United States apparently for the past 14 years, a clause I'd forgotten until I read some stuff this morning. There's also in the 14th Amendment in Section 3, this being one of the amendments enacted after the Civil War, a clause that says if you've previously sworn an oath to protect and defend the Constitution as an officer of the United States, and then engaged in insurrection or offered aid and support to those who engaged in insurrection, you are disqualified from office. You cannot be president, every bit as much as though you were the callow age of 33, the age of a certain young man named Michael Boyer, or born somewhere else, Kenya, for example. Then you are disqualified from office. But the question then becomes, how do you make that determination? How do you determine whether a person engaged in insurrection, and what does that mean? The Colorado Supreme Court's decision offers a long and really pretty well written discussion of that. I found it quite interesting, and I want to. And the result is they've concluded that Trump should not be on the Republican primary. Now, the primaries, I don't when is the primary set, Mike? What is the date for the primary in Colorado? Do you know? I don't offhand. Probably
Yeah,
should.
July or January 5th
I think by January 5th, the ballots have to be printed,
and
and
March
then there will be
4th.
a vote thereafter. And so the Supreme Court says that unless Donald Trump or somebody seeks relief from the United States Supreme Court by January 4th, he will not appear on the presidential primary ballot. Now, we double checked this morning. Seeking relief doesn't mean obtaining relief. So if Donald Trump's lawyers file a petition for a writ of certiorari to the United States Supreme Court, this ruling will be stayed until the United States Supreme Court rules. But right now, the law of the land is that Donald Trump can't appear on a Republican primary, even though the Colorado Republican Party wants him, even though Republicans in Colorado want him. And, just as a 30,000 foot, before we go into the weeds on the ruling, as a 30,000-foot view of this, well, what does this mean for the health, safety, and security of the republic? If members of a state are being told that the candidate they support, and knowing full well where he was in 2020, what he did, if that candidate is declared ineligible for office and people nonetheless want to vote for him, and they're deprived of the right to vote for him, that there can be no more fundamental strike at the core of a constitutional republic with democratic features, which is what we have, than telling people you can't have your candidate. Period. Now let's play this out. Suppose um, Colorado's ruling stands. Suppose Colorado keeps Trump off the ballot altogether. Um, he concedes their electoral votes. He wouldn't need him to win. Didn't have him in 2020, didn't have him, I believe, in 2016. Suppose Donald Trump wins the general election. In other states, he captures a majority of the electoral college, and Colorado's Supreme Court has declared he's unqualified to serve in that office. What then becomes of Colorado? Does Colorado say we want to succeed from the union because we have an unqualified man as the president of the United States? Or does it say, well, oops, we were wrong. We made a pragmatic compromise? There's a very real danger based on the polling data right now that if Colorado's decision stands and Donald Trump is kept from the ballot, he could nonetheless win the presidency. And Colorado would be acknowledging by the court ruling that a man that the chief executive officer of the United States government is occupying office unlawfully, and therefore, what would Colorado do? Would it say we're out of the union? I don't think so. Let's play it out another way. Donald Trump um, um, gets back on the ballot, but now a majority of people have concluded or of the Supreme Court has concluded that he's unqualified for office. Furthermore, he loses by some significant or even insignificant margin the popular vote in Colorado. All of those people are going to say we've got an endorsement of the highest court in our state saying that he is not qualified. The battle lines are beginning to take shape. It occurred to me last night that for the longest time, and regular listeners know this my view at least. I'm not sure where Mike is on it. I don't shut up long enough to listen some days. But I know. I see you wincing there, Mike. Um, but I mean, I begin. I've said before. I think we live in a failed state. The lack of a consensus or anything approaching a consensus on fundamental norms, on common conceptions of decency, makes us increasingly ungovernable. And I've not been really troubled about that for the most part because we're supposed to be ungovernable. That was the point of having a separation of powers in the federal government, make sure it didn't get too efficient. That was the point of dividing governmental power between states and federal government, to make sure all that power doesn't get concentrated in one hand. And so a certain level of raucous dysfunction is what the American experience is all about. And I don't mind that as a matter of law. I think I mentioned earlier in the week I'm reading or listening to Cass Sunstein's book on constitutional interpretation, and he talks about textualism and originalism and the living constitution and judicial review subject to democracy expanding norms. All of these differing ideas, and I thought the ideas that inspire my reading of the Constitution aren't even mentioned in Sunstein's book. I think we begin with a place of darkness. And what I mean to say by that is not a nod to Augustine and original sin, even though he remains my hero, but to the fact that government is an artifice, that in the beginning there was nothing, and that we, the people, created something, and that something is government. And so we begin and should begin any analysis of public institutions in the United States by concluding that any assertion of power is inherently suspect and needs to justify itself. And that justification will come in the form of arguments about legitimacy, and they are usually rooted in consent or Republican governing norms. And I don't mean Republican Party, but the notions of a Republican form of government. When you begin your discussion, however, with the assumption that there should be nothing, that one of the fundamental mysteries of human experience is the fact of government, and that government needs to justify itself, it needs to sing for its supper, that we, the people, as individuals, are the primary reality, and that we are gathered together to be governed by some mechanism. We call it our consent, and that the lineage of that consent needs to be traced by constitutional metes and norms. If you approach the document that way, and you end up in a republic where there is no mutual understanding about basic constitutional facts like qualifications for the president, the office of the presidency, guess what? It's done. The republic is over. And so I begin suddenly to see why Jumpin' Jack Jalapeno Smith, was so insistent in the Justice Department on having the March 4th trial of Donald Trump for his conduct on January 6th take place. Because it was hoped that there would be a verdict, a jury verdict, that concluded that Donald Trump engaged in something that other courts could call insurrection, and that there would have been a full and fairly litigated trial before the American people, at which the case could be made that Donald Trump engaged in conduct that Section 3 of the 14th Amendment disqualified him from office. It's not, we're not going to have that trial now, is my prediction, based on the actions in the United States Supreme Court, both with respect to presidential immunity arguments and with respect to the application of obstruction of an official proceeding arising under 18 United States Code Section 1512. We've talked about that ad nauseum in recent days. But to return to the Colorado Supreme Court case, this now adds a whole new level of complexity to that discussion. Among the things that the Supreme Court did is it reversed a ruling of the lower court. The lower court concluded that Section 3 of the 14th Amendment didn't apply to presidents because presidents were not an office of the United States. We ridiculed that, Mike and I did, when that decision came out a month or so ago. It was clearly wrong and sort of ridiculous in a hyper technical reading of 14th Amendment of the 14th Amendment's Section 3. The Supreme Court of Colorado, I think, got that right. Basically said we're going to rely on a common sense meaning of the language rather than some hyper technical parsing of legislative intent, which might be appropriate in an obscure regulatory context over a highly complex industry. But when it comes down to determining qualifications for office, it doesn't matter. So the court then went on to hold that because he's an officer of the United States, on application of on review of the record before it, Donald Trump did engage in insurrection, and I will always disagree with that decision, not as a matter of politics, but as a matter of fact. As regular listeners know, I spent 5 or 6 months earlier this year on trial in Washington, D.C., representing a member of the Proud Boys in a seditious conspiracy trial. The government never proved that there was a plan coordinated by the White House to use force against the United States government. Indeed, it didn't even argue that Donald Trump was behind it all, because they've never been able to prove the missing link. Whatever it is that Trump said to the crowd, whatever it is that he said in the run up to the election, other people took that as an invitation to come to the Capitol and engage in protest. The government never proved what the January 6th House Committee report asserted, and that is that there was a concerted, centralized effort that the mob, and this comes from page 101 of the Colorado Supreme Court's ruling, that there was a mob that was coordinated and demonstrating a unity of purpose. I mean, seriously? Did anybody from the Colorado Supreme Court bother to familiarize themselves with any of the trial records involving either the Oath Keepers or the Proud Boys? Yes, there was a mob of people there. Yes, there were people who were angry. Yes, there were people who thought the election was stolen. And yes, they appeared in Washington on January 6th. Some of them went to listen to the president at the Ellipse, and some of them were inspired by his speech to go to the Capitol, and there was a riot at the Capitol. But to claim that there was a riot, that riot is an example of a mob coordinated and demonstrating a unity of purpose, is to ascribe to every soccer mob out of control at a sporting event a unity of purpose that there just isn't. Sometimes passions go off the rails and people act, and only in hindsight can you read in to their reaction and a unity of purpose and concerted effort. What's more,
Well, I mean, based on that analysis, how many politicians from the opposite side of the political spectrum should thus be disqualified from holding federal office moving forward?
well, and we'll get to that in a minute, because there's a very dangerous set of factual predicates, I'll call them politically neutering sets of factual and legal conclusions in this Colorado Supreme Court decision that scream out for correction by the United States Supreme Court. But the January 6th report, inspired largely by Liz Cheney, and we talked about her book Oath and Honor earlier in the week. She was a member of the committee, one of the two Republicans on the committee. They came to that report with the assumption that Donald Trump coordinated and directed these activities. And they sought to prove a chain of communications leading from Trump through his senior associates or people in the White House to leaders of people on the ground to activities on the ground. The committee report asserts that as proven, but it's not. There's no evidence of that. What there is evidence that Donald Trump engaged in incendiary speech. People took him seriously and acted. And that's different than saying he directed this. It may not be different than saying he caused it. But if he did cause it, does that necessarily mean that he engaged in insurrection? Now, the Colorado Supreme Court has a good discussion of insurrection, has a good discussion of sedition, has a good discussion of rebellion. And what you find is these are public reactions to public authority that are arranged along a scale of increasing intensity. Rebellion is an open declaration that you want to replace one government or form of government with another. And no
Norm,
one thinks,
is it fair to ask at this point? I'm sorry to interrupt. We've got a number of people who are commenting on both YouTube and Rumble this morning, but my question is, with everything in full view and attempting to get some altitude and look at this in a broader way, is populism on trial right now?
that's a great way to put it. And let me, so let's reframe the discussion of rebellion, sedition, and insurrection as an indictment of populism. If the so what is populism? Populism is the people saying we feel as though the institutions that govern us aren't listening. We feel as though the elites that occupy these institutions come from a different point of view. We are fed up. What did the guy say in the movie Network? We're mad as hell and we're not going to take it any longer. And the point of having the ability in the First Amendment to petition the right of the government for redress of grievances and the right peaceably to assemble and the right to speak out is so that the people can be heard. Because, the Colorado Supreme Court refers to we the people, as the beginning of the preamble. And that is the governing myth of our society or of our government, that somehow we're governed by our consent. It's a myth. I no more consented to this cockamamie system of checks and balances, this, that, and everything else, than I consented to be born with a big nose and a bad attitude. But I find myself in a world governed this way, and I make accommodations to it. And when it doesn't work, I react, and that's what people did on January 6th. It wasn't a rebellion, the Colorado court said, because there was no desire to replace government. I remember cross-examining one of the snitches, the only snitch who testified in the Proud Boys trial, Jeremy Bertino. And I said, so you guys had a plan, did you? Well, we didn't really have a plan. Yeah, now I know it was an implicit understanding. Did you think you were going to take over the government? I don't know what he said even. I said, which one of you geniuses was going to be Secretary of the Department of Transportation? And everybody laughed because everybody knew that's not what it was. It wasn't a rebellion. Was it sedition? Now, the jury in the Proud Boys case concluded sedition was was using force against the authority of the United States government. So when people protested, when people went into a building without authorization, when there were confrontations with law enforcement, that was use of force, and it was against the authority of the United States government. But that's awfully thin gruel, because every riot in which anything is thrown at a law enforcement officer is potentially sedition at that point. And I wait with bated breath to see what will ever happen to those who engaged in arson and riots in the mostly peaceful protests of 2020. And we all know what the answer to that is: nothing. So was it insurrection? Insurrection, according to Noah Webster, is an open and active opposition to execution of the law. And, arguably, what occurred on Capitol grounds on January 6th of 2021 was insurrection, because people wanted to stop the steal. They entered the building with the intention of stopping the counting of ballots that they regarded as illegitimate. And so, arguably, this was an insurrection. Did Donald Trump engage in insurrection? That is the pivotal $60,000 question in the Colorado Supreme Court case. And one of the claims that Trump's lawyers made is that it wasn't, that he engaged in speech that was protected by the United States Constitution. The Constitution basically, although it says the following: Congress shall make no law and, limiting freedom of speech, no branch of government can. And they can, and what by making of laws meant more than simply passing of legislation. It means reacting with the force of government or policy or whatnot. Um, did Trump engage in speech? Did he incite the crowd to engage in insurrection? This is why I part company with the Colorado Supreme Court and why I'm certain the United States Supreme Court will hear this case. The Colorado court says he did engage in incitement, and they applied the traditional tests of the courts, including the Brandenburg decision, and basically said that he engaged in speech that he knew and foreseeably should have known would result in violence. He was charged with no crime. He was not charged with a crime that could involve incitement because, candidly, the Colorado Supreme Court's ruling is just dead wrong. Donald Trump did not engage in incitement within the meaning of the United States Supreme Court's most recent decision on speech and violence, the so-called Counterman versus Colorado, as luck would have it, decision. And that was a true threat case. And the court held that in order to engage in a true threat, the person had to know in their mind that the speech they engaged of would be regarded by another person as threatening. Did Donald Trump, now, applying that line of and Counterman, the Counterman court acknowledged that having a true threat sort of doctrine on the books had the potential to chill speech. It had the potential to chill speech because it gave to the government the ability to prosecute otherwise protected speech and say, hey, it was a threat. That danger is even more acute in the incitement context as applied in politics, because what you do when you incite someone is you inspire them to act. And isn't political speech in an election year designed to inspire people to act? I want you to go out and protect the republic, protect the borders, protect your way of life. If you don't act, we won't have a country anymore. I want you to register to vote. I want you to get your neighbors to vote. I want you to fight for America. I want you to put America first. Under the Colorado Supreme Court's ruling, all of that language could be taken to be an incitement to engage in insurrection if any of the listeners heard that and they acted in open and active opposition to the government. So any non incumbent who is seeking to inspire people to vote against the incumbents could be charged under this tenuous ruling with engaging in insurrection, or from a criminal context with incitement. That can't be what the Colorado Supreme Court meant, and it cannot be what the United States Supreme Court will uphold, because buried within the Colorado Supreme Court decision are norms of compliance for political candidates that are antithetical to everything in our political tradition. Not only can you not revolt against attacks on tea, I mean, apparently all those people who engaged in the Boston Tea Party in 1773 should be strung up because they engaged in insurrection and sedition. But every person who engages in incendiary speech is also now engaging in incitement as well. And the Supreme Court has a long line of cases that say not even an abstract call for violence at some future date is against the law. And so, this decision is of historic magnitude, not just for what it does to the 2024 electoral playing field, but for the shadow it casts on free speech in the United States, not just for ordinary citizens. I guess we're all expendable in this, the best of all possible worlds, but for political candidates who go out to the stumps and they pitch their vision and version of America to strangers, trying to motivate those people to do what elections do, to replace one government with another. And so I'm entirely confident that this case will be heard by the United States Supreme Court. Another issue that we didn't talk about is whether, the 14th Amendment, Section 3 is self-executing. Does it give to the states the ability to determine what is and is not an insurrection? Colorado held a 5-day hearing. It didn't say to the Secretary of State, you can decide on your own in the office over tea. There was an evidentiary hearing. The court accepted into evidence the House January 6th report, applying various exceptions to the hearsay ruling. And as I read that, I couldn't help but think that Liz Cheney probably wet herself in delight, because this was the reason. That she wanted to participate in the January 6th investigation, and she made it clear from the moment that the committee was impaneled to investigate that she wanted to make sure that Donald Trump would never be president again.
Well,
She
and
brought it
and
to
I have to
Cheney
bring
that
this up too, Norm, because you and I and you brought this issue to bear, and I think I probably bird dogged it a bit more than you anticipated, but recall when that January 6th select committee was formed, you and I talked about the procedural ills affecting the valid and lawful formation of that committee, in that it was not properly constituted within the parameters of congressional procedure. And so the report that emanates from the January 6th House Select Committee on in general was comprised of how many members
well,
from
I
each
think there were
house?
2. I mean, it was 2 Republicans, and I don't remember if it was 5 or what the number was of Democrats. But, Cheney, I'm no fan of Liz Cheney, as regular listeners know. I didn't much think much of her Oath and Honor book, but she does raise a good point, and that is when the notion of a bipartisan committee commission was floated, Republicans opposed. McCarthy proposed a slate of candidates to the House side of the committee, and Pelosi wouldn't seat them. They included among others Jim Jordan, I believe, of Ohio. And so Cheney and others argue that the Republicans, in effect, waived that issue by failing to
Yet
participate.
Cheney argues that. And does anybody
Well,
here,
some
any
courts, no, some courts,
self-respecting individual paying attention to this think that Cheney represents anything to do with a Republican platform in theory at this point?
Some courts, however, have rejected the argument that it was an improperly constituted committee when it was raised when people raised it to challenge subpoenas. So I get that, but I do think that using the House J6 committee document as evidence in an insurrection trial is kind of stacking the deck. I've read
Kinda.
that committee
That's what
report
this entire
carefully.
thing is premised on. The original cause of action submits to the court for determination the issue of whether Trump, by clear and convincing standards, engaged in an insurrection. And now on appeal, even though that court determined that he, by clear and convincing evidence, was responsible for the insurrection, decided on an interpretation of the election statute at bar that it was not applicable to the situation, and thus he could be put on the primary ballot, Republican primary ballot. The appeal court here has reviewed that court's ruling on the issue of insurrection, agreed with it, and then sought to determine from a historical perspective the meaning of the words in the election statute at bar, and overruled the lower court's interpretation of its own election law. Now,
It's
mind
good.
you,
Mhm.
I would like to point out something else that I found interesting. I think that you may have as well. Let me get to the one that's actually closer to the top here, because there's a really important footnote, Norm, that I think I pointed out to you, and I'm not sure if you went down that rabbit hole with me. And give me one moment here to find it. But I did quote it to you, I think, this morning. Here it is. At the bottom here on page 21. Colorado eliminated presidential primary elections in 2003. In 2016, however, voters restored such elections through Proposition 107, a citizen-initiated measure. Proposition 107, ballot initiative number 140. So there is the link. You can go and find it. In a 2017 cleanup bill, the General Assembly adopted several amendments. So this is 2017. Trump is seated as president. The General Assembly adopted several amendments to the citizen-initiated measure, quote, to facilitate the effective implementation of the state's election laws. Relevant here, the legislature directed challenges under Section 1412044 away from the secretary, that is the named party in this lawsuit, Griswold, and instead to the district court through Section 11113 proceedings. That
Well,
has remained otherwise unchanged. So
I
instead of this being put back to the Secretary of State for the Secretary of State to come to a determination, In 2017, Colorado changed its law to make sure it could submit this exact issue to the district court for
I
determination.
actually, I don't find that troubling because what I take that to mean is that there had to be some sort of judicial proceeding to reach this decision, that it wasn't going to be left merely to administrative fiat, and that's what happened. What I think this illustrates, though, is the need for federal standards for federal election law. I mean, the Constitution right now gives to the state the ability to regulate the time, place, and manner of their elections, and
Well, it's
so forth.
troubling to me because this is an issue, this is a ministerial issue, Norm. They deb
Is it?
the court here debated a qualified candidate, and we're not talking about and there are other safeguards as to the qualifications of a candidate there that are set forth in this lawsuit in full. As the court is discussing the merits of the case, it sets forth the
So
standard. It
I want to
requires that party to have 20% of the vote in the previous election or, you know, 5 or the candidate to have 5,000 signatures. There's all these other things that are there to ensure that a qualified candidate is put there. But for the legislature to have put a cleanup bill before itself for to be ratified and signed into law by the governor to say any issues that fall underneath this specific section are going to be submitted to the district court rather than to the person, the Secretary of State historically. And so the fact that so I have no idea about the history of why Colorado would have eliminated presidential primary elections in '03 and then seek to bring them back. I don't know that history. But this is troubling to me because the entire issue that we are contending with here is the fact that somebody submitted this issue to the court and built an entire factual record out of whole cloth.
But wait, but see, I want you. You used the word ministerial before. Ministerial is an act that takes place without discretion. A person is able to look at something and applying a rule reach the result without requiring interpretation. So, for example, Mike, under Colorado law, a person wanting to appear on a primary has to sign a certification saying they otherwise meet the qualifications. They're over 35, were born in the United States, or a natural born citizen, and so forth. If they misstate that, they can be charged with perjury. That's the point of having them say it under oath. But if or if a person under the age of 35 appears at a Secretary of State's office with a petition to go on a presidential primary ballot, the Secretary of State office can say, just like that, ministerially, you're not qualified. Your documents don't support that you meet the minimum qualifications. That I get. But declaring whether someone is engaged in insurrection absent a hearing. I don't think that can ever be a ministerial act absent a hearing. And this is why I think the Jack Smith prosecution was so important to Democrats, and to have it heard and decided early as possible. Because if they could get a final judgment of a district court to say that Trump engaged in something that looked like insurrection, they could present that to a Secretary of State's office, much like a birth certificate, and say, here, this is ministerial. This judicial act is as conclusive as a birth certificate. In the absence of that, I think you got to go to court and develop a record. And so I don't find fault with that in the Colorado case. I find fault with the analysis, and I think there need to be uniform federal standards.
But what
So
gives that court jurisdiction over an issue such as insurrection? What gives that court and that's the issue. I think that that gets us back to where we began with
because
this case
all
being brought
courts in the United States have concurrent jurisdiction over matters of law.
and so we
So
could get
a state
49
court, no,
other
hold on,
versions of this.
yeah, we could. This is this I call this falls into the category of things in the law which I call the vagaries of federalism. And what I and law is not mathematics. If you submit to any mathematician a statement in the form of 2 + 2 = blank, all mathematicians, competent mathematicians, should reach the conclusion that that's 4, and that goes without saying. And it approaches something like a ministerial conclusion. Engaging in insurrection, I think, is a little bit different. And who gets to decide that is an important question. I think Colorado basically said that when questions about qualifications of that sort that are non-ministerial arise, a person is entitled to a hearing. And thus, Colorado distanced itself from those who claimed that 14-3 was self-executing. That a person, a secretary of state, could decide that without a hearing. But as to your point, Mike, who gets to decide that? Here's what I understand about the jurisdiction of courts in the United States. State courts have concurrent jurisdiction over matters of state law and federal law occurring within their boundaries. If a person brings a purely federal claim to a state court, they have a right to do so. However, a party who is the defendant in that action can ask that the matter be removed to federal court because it raises a federal question. And so the federal courts have exclusive, they have the ability to remove federal claims themselves. They also have the discretion not to hear a state law claim that's brought before them. So if you bring a hybrid state federal claim to a state court judge, that judge is obligated to rule on both the state and federal questions. If you bring a only federal claim to a state court, the parties involved can ask that it be removed to federal court. The state court loses its jurisdiction. If you bring a hybrid state federal law claim, in other words, a claim with a federal action and a supplemental state law claim, to a federal court, the court must decide the federal action, but it can abstain. It can decide not to decide the state court action. And so I don't, and so the result is that
Shout out to Civ Pro 1.
when it comes, well, but when it comes down, but when it comes to differing interpretations of novel legal theories, Mike, you really could have 50 different
Well,
interpretations.
yeah, I think that that is what I'm struggling with on this, as a procedural matter is the fact that, we kind of end where we begin. I wanna pull up this comment that I didn't wanna interrupt you
Well,
earlier.
let me just finish this little mini riff. This is why the United States Supreme Court has to and will hear this question. And candidly, when it comes to matters of federal election law, I think that there should be a uniform federal election law, and this power to regulate federal elections should be taken from the states.
Well, and I think the reaction to that is gonna be one of mistrust because the
Mhm.
consolidation of any power within the federal judiciary or otherwise is something that this populist movement that Trump is at the front of is highly skeptical of, right?
Well, you're right. I reserve the right to retract that opinion on further reflection.
Reserving all rights, Norm Pattis. Didn't Michigan do the same thing as Colorado, and it was overturned? Question mark. Now, I don't want to. I don't know, Janice, in terms of answering the question directly on the substantive merits, but this is where we began, Norm, in terms of your concern that the long range implications of this are that Trump could survive this and all of the other lawfare being lobbed at him, he could successfully become the 48th president or the 47th president of the United States of America. And because of this process, his second term can be just as embattled, if not more embattled, because of what we are seeing now, right? So in
Well,
much the
I
same
don't think
way
there's
as
any
as
question about it.
Vivek has said that he was deprived of the 2016 election, Vivek has gone on record to say that he's seen enough now of 2020 to say with confidence that the election was engineered, right, from an algorithmic perspective, that there was interference. And he has also gone on record to say that he goes so far as to say that Donald Trump was disenfranchised from his valid win in 2016 in the way that the mechanisms of Congress were used against him throughout his presidency. That seems to be a pathway that the Democrat platform is very comfortable with because look at the way that every available tool is being used. So I think my concern with all of this is not necessarily that this derails Trump's prospects of appearing on the ballot or even being elected, duly so. I think I share your concern, Norm, as to what it means for the other half of the country that is okay with the mechanisms being deployed and the efforts being undertaken to stop that from happening when it does happen.
2024, every election, participants say this is the most important election in our history. Um, I'm not running for office. I haven't endorsed a candidate. If I had to vote today I would vote for Donald Trump, candidly, over the alternatives that I'm aware of right now, simply because he expresses the frustration of every man in a world in which every man feels as though he's losing his place. And simply, there was a fascinating opinion piece in the New York Times the other day that said, people are arguing over who Trump is from the extremes. On the left, he's an authoritarian, right wing zealot, and on the right, he's going to make America great again. When he was in office, he was actually somewhat pragmatic, and he engages in mobilizing speech. The fundamental question people continue to fail to ask about Donald Trump is what makes this canary in the coal mine so attractive? The question that they should be asking is not what is the canary saying, but why are people responding to it? And they're responding to it because they're frustrated, they're angry, and there's a deep-seated sense in the United States that the country is not working. And if it's not working for a substantial number of people, they're going to withhold or withdraw their consent from governance. And the result of that will be an increase in chaos and a cascading failed state that literally now could divide along state lines in such a way to make succession seem like a reasonable possibility. And succession, ladies and gentlemen, was the talk that began the Civil War in the 19th century. Colorado's Supreme Court has basically said to Colorado residents who want to vote for Trump, your vote doesn't count here. How long will those residents feel that they're being heard in Colorado? How long will they want to remain? And what sense of confidence will they have in Colorado institutions? The United States Supreme Court has to act on this case. It has to consider both the First Amendment implications, the so-called incitement ruling that the Colorado court engaged in. It has to decide the proper procedural mechanism for deciding claims arising under the 14th Amendment, Section 3. And it has to provide some guidance because the country now is at a tipping point. And with state Supreme Courts tipping in different directions and tipping against the person who's polling as the leader for president of the United States, it is hard to walk away from this discussion with anything other than a profound sense that there's a darkness on the horizon that might consume all that we cherish and hold dear.
I can't disagree with you, Norm. I think that what we have in the chat right now, by the way, we've got um, a great number of people watching live on both YouTube and Rumble. So thank you for being here and thank you for all of your comments as well. I want to spotlight a few of these. Jackson Barrett, you've made several very salient points. One that I'm going to pick out here: courts are accepting false narratives as if they are facts and then making rulings based upon perceptions. And I think that echoes and that is very it's a great consolidation of what we've talked about here today, Norm. Um, MDMA for PTSD said election day equals federal holiday, 1 day voting on secure paper ballots counted at local precincts. I don't disagree with that as well.
With a voter with identification. I mean, I just love the memes I'm seeing online about everything you got to produce identification for except voting for the most important officers in the land. If you want to sustain the myth that we're a people governed by our consent, then let's decide who those people are. It's not every Tom, Dick, and Harry who wanders in and is pointed at a polling place or not, whose ballot is harvested for them and a ballot cast for them by some party official somewhere. If we, the people, are going to govern, if we want to have efficacy in our own skins, a sense of empowerment in our own communities, then it begins by voting in our communities, by recognized norms and standards.
Be here well outs him or herself as a Brit of sorts. This is the legacy of George Soros. Look at these so-called NGOs bringing these lawsuits. Soros is contributing funds to their organizations spelled with two S's, not one.
So why don't we engage? Why doesn't everybody send George Soros jelly donuts? I mean, he looks like he died 10 years ago. Maybe we can hasten the process. Eat yourself to death, George. Say goodbye.
Norm, I think that now is a good time to end here and perhaps use tomorrow for what we discussed as perhaps a 2023. At least we can start 2023 year in review. Top stories of the year. What we'll do is begin with the 5 predictions that we outlined at the beginning of this year, and then move to what we see as the dominant stories this year. We've given a little bit of a teaser here on the screen. I'd also like to continue to visit this case and monitor what the GOP in Colorado does. We've seen that they are threatening to cancel the primary altogether.
Genius move if you're the Colorado GOP. But again, it's a road to nowhere. The Colorado GOP said, you're not going to put Trump on the candidate. You're not going to put our candidate on the primary ballot. You know what? We're not going to have a primary. But where are those people going to go? Colorado, think.
We hear well as an Aussie and female. So nice. Uh, More Aussies. Where's Hans today? Miss
Hey,
Hans.
where's that fellow who was trolling us yesterday? Is he? I guess he's not here anymore
He's not
today.
on YouTube today. If he is, he stayed quiet. Anyway, Norm, thank you for your patient analysis of this case. I do feel confident that you and I are perhaps uh, we are among the elite few who have taken the time to do something really revolutionary in this day and age, and that is read. So
And I'll be spending more time. I read the majority decision before the broadcast this morning. I didn't get a chance to look at the two minority decisions. But folks, read these decisions. Learn what it is that courts are saying the Constitution gives you and ask yourself, is this what you want?
yeah,
Constitutional law is supposed to be the people speaking to set the metes and bounds of the government that controls, if not controls, at least shapes their lives. And the battle for constitutional law is not a lawyer's pastime; it's a popular pastime. And Mike asked earlier about this as a direct assault on populism. I would say it is. In the
I think
same
that
way
that's
that
what we're learning. I think that
increase
that is what
taxes were.
I think that's what we're realizing right now is that this entire effort, if we gain altitude, if we allow ourselves the patience and the bandwidth to really think about what the title to this book is that's being written, or at least this chapter within the book. This is a top-down movement to suppress populism by any means necessary, at least from a civilized perspective. I put civilized in air quotes. For all of you who would like to read this is becoming a bit of a platform issue for me, as it were, that any of the media outlets reporting on this are worthy of distrust if they do not give you the tools necessary to go and read on your own. This is on the Colorado Judicial Branch's website. It is under the announcements section and it sits on its own. You may find it. It is called Anderson v. Griswold. I have put on the banner here the case number, and you may go and click through. You do not need a Pacer account. There is no need for a username or a login. It is free to the public. You may go, click it, download it, read it, internalize it, think about it, and ask questions. Perhaps that's what we'll do Friday, Norm, is maybe have a Q&A. And we invite all of you who are watching now to take the time over the next couple of days, read it, and let's have a discussion about what is contained within this case. I think it's a great case study for us on law and legitimacy moving forward. I know we've got pressure to get back to more of the fundamental constitutional issues and doctrine in 2024, which I'm happy to do because I have the best teacher in the world right here with me every morning. So we'll do that. But again, I encourage you to go and do the reading on your own and you just print it and work through it. Tonight, I'll be reading through the dissents because it was a 4-3 decision. This was not a 7-0 or a 6-2 or a 6-1 or a 5-2. This was a 4-3, so it is a split decision, which gives some credibility to the dissents. And I think that we'll do that tomorrow as well.
Yeah, yeah, you do read through it. We'll close on this note. I engage and have engaged over 30 years in lots of litigation, lots of it constitutional litigation. And I remember many years ago, an Italian American woman felt aggrieved, an immigrant, by what a local school board had done to her. And she came to see me, and I was listening to her, and I wasn't sure she had a case. And she finally looked at me and she says, when I come to this country, I read the Constitution. It says we the people. One of those people. And I took her case. I don't remember how it worked out, but I was so inspired by that. She transformed herself by those words, and you should transform yourself by those words. And the promise of populism is that our communities can be transformed by those words. Don't let the politicians misuse them. Don't let them take your power of speech away from you. Return tomorrow morning. We'll resume our discussion. Mike, how do people find us?
You can find us every day here on YouTube, on Rumble, and on X at LawPod Daily. You can also find the audio-only versions of these streams on Apple Podcasts, Spotify, Google Play, Overcast, Audible, wherever you find premium podcasts. Dawn, I will indeed, right now, I will post the link to the decision on locals. So if
I
you
want to
are
hear from Dawn McNeil. Didn't her team engage in misconduct in the Law and Legitimacy fantasy football program? Didn't
championship interference is what it engaged in.
Yeah, stay in California, Dawn. Shouldn't you be out playing paddleball right now? You retired sociologist, you. Thanks for
Uh,
tuning in, everybody. We'll talk to you tomorrow.
Absolutely, Norm. See you tomorrow. Bye, everyone.